The courtroom had been loud all morning. Arguments, objections, voices rising and falling like waves. Then the defense attorney said 5 quiet words. "Your Honor, call the bailiff." The room didn't understand why. The prosecutor paused mid-sentence. The jurors exchanged confused looks. Because bailiffs usually didn't bring evidence. They kept order. They escorted witnesses. They opened doors. But today, the bailiff walked toward the bench, carrying something thin and grey, a single folder, and the moment the judge looked inside it, the entire courtroom went silent. Before we continue, subscribe to the Unheard Witness, because sometimes the truth doesn't come from the witness stand. Sometimes it's hiding in a record nobody expected to see. The defendant sat motionless at the defense table. His name was Aaron Whitlock, and 34 years old, construction foreman, no criminal history. But today, he faced a charge that could send him to prison for years: fraud. According to the prosecution, Aaron had transferred company money into a private account, nearly $90,000. The company owner had discovered the missing funds 2 months earlier, and the transaction records pointed directly to Aaron's employee credentials. The prosecutor turned toward the jury. The money was moved using the defendant's access code. He held up printed financial logs. The transfer happened at 9:17 p.m. He looked across the room at Aaron, and the defendant was the only employee with access to that account. Aaron didn't react, because the evidence sounded simple, clean, almost impossible to argue against. The prosecutor continued. 10 minutes later, the funds were moved again into a personal banking account. He paused. And that account belongs to the defendant. The jurors wrote notes, numbers, times, names, everything lined up neatly. The prosecutor stepped closer to the jury box. This was not an accident. He raised the transaction log. This was theft. The courtroom murmured softly, because money trails rarely lie. The prosecutor returned to his table. No further statements. The judge turned toward the defense. "Counsel." The defense lawyer stood slowly. He didn't rush, didn't argue. He simply walked toward the center of the courtroom. "Mr. Whitlock has worked for the company 8 years. He spoke calmly. Never disciplined. Never accused of misconduct." The jurors listened. But today, he is accused of stealing $90,000. The lawyer paused, and the evidence appears to show exactly that. A few jurors nodded slightly, because even the defense sounded like it accepted the numbers. The lawyer continued. "But there's one problem." He turned toward the prosecution table. One small detail. The prosecutor leaned back, curious. The defense lawyer looked towards the bench. "Your Honor, before we continue, the defense requests the court review an employment record." The judge raised an eyebrow. "What record?" The lawyer answered simply, "The building access log." The prosecutor frowned. "That's irrelevant." The lawyer shook his head slightly. "I believe it's very relevant." The judge considered for a moment, then nodded toward the bailiff. "No, retrieve the record." The bailiff stepped out of the courtroom. The room filled with quiet whispers, because access logs rarely mattered in financial cases. Minutes later, the bailiff returned, holding a grey folder. The judge opened it, read the first page, then slowly looked up. "Counsel." The judge's voice had changed. The defense lawyer nodded. "Yes, Your Honor." The judge leaned forward. "This record shows something interesting." The prosecutor shifted in his seat. "What does it show?" The judge looked back at the document, then spoke carefully. "The building security system logs every employee entry and exit. He tapped the page. At 9:17 p.m., when the transfer occurred, the courtroom leaned forward. The defendant's key card was used to enter the building. The prosecutor smiled faintly. That supports our case. The judge continued reading. But the record also shows something else. The room quieted again. The judge turned another page. The key card was used again at 9:18 p.m. The prosecutor shrugged. Employees sometimes scan twice. The judge looked directly at him. Yes, but not from two different entrances. The courtroom stilled. The prosecutor blinked. Two entrances? The judge nodded. This log shows the same key card scanned at the front door and the rear door. The jurors leaned closer. Within 60 seconds. The prosecutor frowned. That's not possible. The defense lawyer spoke quietly. That's exactly the problem. The judge looked back at the folder. The front door scan shows entry at 9:17 p.m. He turned the page again. So the rear door scan shows entry at 9:18 p.m. The prosecutor's confidence began to fade. That must be a system error. The defense lawyer shook his head. The building uses two independent scanners. He paused. They cannot record the same cards simultaneously unless two copies exist. The courtroom murmured. The judge leaned back slowly. Two copies of the same access card. The prosecutor looked toward Aaron at the defense table. But the defendant only had one. The defense lawyer nodded. That's what everyone believed. The room felt heavier now, because if someone else had a duplicate card, then someone else could have entered the building. The defense lawyer stepped forward again, and the security record shows something even more interesting. The judge flipped another page. His eyebrows lifted slightly. Sure, continue, he said. The defense lawyer faced the jury. The rear entrance scan, the second one, he paused, occurred while the defendant's car was recorded leaving the parking lot. The courtroom erupted with whispers, because now the timeline made no sense. Aaron Whitlock couldn't be inside the building and driving away at the same time. The prosecutor rose quickly. Your Honor, we need verification. But the judge raised a hand. The bailiff has already verified the log with building security. He tapped the folder again. The record is authentic. The courtroom fell completely silent, because the evidence everyone trusted had just revealed something impossible, and it took one record carried quietly by the bailiff to show it.